Okay, here goes Tony. And we're almost live. It's still loading.
Okay. There she is. Hey there, Tony.
We're live.
Okay, the meeting will now come to order. Welcome to the September 8th, 2021 meeting of the Durham County Board of Equalization and Review. My name is David Smith and I'm the chair of the board. I would like to start by acknowledging that we are conducting this meeting using a remote electronic platform as permitted by Session Law 2020-3. The Board of Equalization and Review is a quasi-judicial board that is governed by the North Carolina General Statutes. The board conducts evidentiary hearings on appeals from appraised real and personal property tax valuations. Today's meeting will proceed much like an in-person meeting of the Board of Equalization and Review. On the screen, you will see the members of the Board of Equalization and Review. Additionally, tax staff and representatives from the county attorney's offices may be present in the remote meeting. Appellants and their witnesses, if any, were required to register in advance and are also attending the remote meeting. When a case is called for its hearing, speakers will be prompted within the remote platform so their video can be seen. The chair will swear in applicants and witnesses at the beginning of each case. Staff will present each case and applicants will then provide their evidence. Control of the presentation and screen sharing will remain with the tax staff. Today's meeting is being broadcast live on the county's YouTube site, and a link to this broadcast is on the website for the Board of Equalization and Review. Before we begin the evidentiary hearings on today's agenda, I would like to provide some information about steps taken to ensure that each party's due process rights are protected as we proceed in this remote platform. Each applicant on today's agenda was notified that this meeting would be conducted using a remote electronic platform. During registration, every applicant on today's agenda consented to the board conducting the evidentiary hearing using this remote platform. We will also confirm today at the start of each evidentiary hearing that the participants in the evidentiary hearing consent to the matter proceeding in this remote platform. If there's any objection to a matter proceeding in this remote platform, the case will be continued. Notice of today's meeting was provided by publishing notice in the newspaper and by mail to the applicant. The newspaper notices for today's meeting contain information on how the public can access the remote meeting as the meeting occurs. These notices also contain information about the registration requirement for the meeting, along with information about how to register. All individuals participating in today's evidentiary hearings were also required to submit a copy of any presentation, document, exhibit, or other material that they wish to submit at the evidentiary hearing prior to today's meeting. No new documents will be submitted during today's meeting. All decisions of this board are subject to appeal to the North Carolina Property Tax Commission. Actually, all decisions are not appealable, are they? I mean, like penalties, I don't think are appealable. As I've been reading this for a year now, that sort of occurs to me. Anyway, that's something we could look into. Okay, all right, well, let's get started. First, we have the consent agenda, and those are items 1 through 22 on our agenda. Do I have a motion concerning the consent agenda?
Accept it and no response.
Yeah, consent and no response, consent agenda. And do you have a motion regarding?
I move that we accept the items 1 to 22 consent agenda.
Do you have a second?
Second.
All those in favor say aye.
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 All right, let's move on to item number 23. Teresa, what is a
sorry. We're going to start off with 24 through 33, and then Teresa will be last. If that's okay with you, Ms. Okay.
That's fine. That's fine. Okay, Amanda, there you are. Let's get you sworn in. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Okay, what do you have for us on these items?
Well, let me give you my name and title. Amanda Markle, Deputy Assessor over Individual Personal Property and Land Records.
Okay.
So items number 24 through 33, it's a variety of elderly disabled exclusion and full exemptions. All of the applications meet the requirements for their prospective exemption or exclusion type, with the exception of the late application. So the applications for the elderly disabled were due June 1st, and for the exemptions, January 31st. So all of these, the applications were submitted after the deadline. So we are requesting approval of the late filing.
Okay, any questions or discussions from the board? Then I'll entertain a motion regarding items 24 through 33.
I move that we accept items 24 through 33 as timely.
Do I have a second?
Second.
All those in favor say aye.
Aye.
All opposed? Okay. All right, then we'll go back to number 23. And let's see, Teresa, I need to get you sworn in. If you raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name and position with the county.
Teresa Williamson. I'm the tax division supervisor over land records and individual personal property.
Okay, and what is the PUV program?
It's the present use, is a present use application. So this applicant applied for agricultural, and he was applying for continued use. And so he met all the requirements except of the late list. He filed late. And so we're asking the board if they would approve the late list.
Okay. Any questions or discussion from the board? Then I will entertain a motion on item 23.
I'll make a motion, we accept.
Have a second?
Second.
All those in favor say aye.
Aye.
All opposed? Okay, it carries. All right, so let's move on to the residential appeals. Do we have anybody here? Ms. Austin, I see you. So
Yes.
you're the first one on the list. So let's go with that. Travis, are you here?
I'm here.
Okay. Ms. Austin, you're muted. I don't know if you can unmute. I'll get you. Yeah, okay. I'm going to get you sworn in first, and then we'll come back to Mr. Westry, all right? You will raise your right hand, please. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And are you comfortable using this format, this Zoom format for your appeal?
Yes.
Okay. All right. We'll come back to you. I'll speak with the staff next. Okay. Mr. Westry needs to be sworn in also. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name and position, please.
My name is Travis Westry. I'm a residential tax appraiser for Durham County.
Okay. And I believe this is one that we had heard before and deferred due to square footage. Is that what the difference was, or the condition?
No, the square footage was accurate, but the problem was the condition of the property, where we had it average. The homeowner felt like the condition was below average.
Okay. And you went back and looked at the property. Is that correct?
Yes, went back out and looked at the property, and the condition of the property matches to the neighborhood. We didn't see any deficiencies in the property compared to other properties in that neighborhood. So we kind of justify that it's still pretty much average.
Okay. All right. Thank you. Ms. Austin, what do you have for us?
Okay. First of all, when it was deferred, it was the square footage is not 2,600 square feet. So I'm still contesting that also. And the condition said, well, that still wasn't what was the primary concern. I said that there was a wide disparity among values and taxes in the same neighborhood and even among houses on the same street. And this was submitted with the evidence the first time. I was a little nervous last time and didn't read that onto the record, but you have that from my first appeal, 26 Gloucester Court, 229-092. 24 Gloucester Court, 231, 889. And Gloucester 17, my property is more similar to these properties in terms of square footage, age, and condition. And the last thing that came up for the deferral was the fact that Mr. Westry said at the time he did not know it was rental property.
Okay, ma'am, did you, those properties you just mentioned, did you submit those to the tax
I
office?
did. I submitted them to this body by email by mail the first time. So this is not new information. 26 Gloucester Court and 24 Gloucester Court.
All right, well, let's try to get the square footage squared away. So did Mr. Westry come back out and remeasure your property?
I don't
yes.
live there. That is rental property.
I see, okay. So Mr. Westry, you did come back out and remeasure?
Yes, I went back out and verified our current measurements.
No,
And we
I'm
did,
sorry, that's not accurate. Now we can go out there together, or I can get somebody else to go, or I can find where I initially bought the property. That is not accurate.
Well, where does your square footage come from, Miss Austin?
I bought my late husband and I bought the property, and it was not 2,600 square feet. We did apply once for a permit to build a garage, which we never did. He passed away. So I don't know where Mr. Westry went and where if I have to now, I keep documents. I can go back and try to find the initial purchase, but I know it's not 2,600. That's more like where I live now. So I don't know what, and I'm sorry, Mr. Westry, that is not correct.
Well, if Mr. Westry went out there and measured it, unless we've got some other evidence that shows a different square footage.
Well, we can get that. What is my next step then? Because that is not accurate. What figure did you come up with in terms of adjusting the taxes then? Because there is wide disparity even on the same street built around the same time.
Let's deal with the square footage first, okay? So, we're going to use Mr. Westry's square footage unless if you come up with something and show it to him that's different, he may be able to adjust it, but unless we've got something, we don't have any evidence from you of a square footage, so we'll have to accept his.
Okay, well, I can come up with something. I was thinking that the last thing that you would need would be the square feet. It's not even, I told you that the last time, but I can get that. I was thinking that since he said the last time he didn't know it was rental property, that somehow that would have something to do with it. And the list, even though I didn't mention it, I had sent it to you about 26 Gloucester Court and 24 Gloucester Court. And the comparables that you all listed were properties that had been since improved. So, you're talking apples and oranges. I'm just asking for fair and equitable treatment.
Well, so you're basing your value, what do you think the property is worth?
Well, we put on there 230 for taxable property.
And
what was your, I'm sure still coming back that I don't know where Mr. Westry went to come up with this in terms of the condition and the square footage.
Okay, well,
I just want that on the record.
Okay, Mr. Westry, how did you judge the condition of this property?
I judged the condition on the property based to the comps and the neighborhood. That the house, as I mentioned before, the house is in average condition compared to the rest of the neighborhood. And I used that with the comps as well. So even the comps that I provided, all of the houses are listed as average, just like this home.
Okay.
But there were wide disparities even on Gloucester Court. Now, some of those other ones that he's talking about have obviously been enhanced or improved.
Okay, Mr. Wester, did you have a chance to look at the comparables that she provided?
Yes, and I think we had mentioned this before. A lot of these comps were homes that were not sold. They were just recent, they're just similar homes in the neighborhood, but they were not sold during this time period.
Are they just
That's
tax
because
value?
those are the owners who were, well, one of them at least is the owner who was there when I was there, when we lived there.
So are these just tax values? She didn't provide any comparables? Is that what you're saying, Mr. Wester?
Yes, I didn't have any comparables to go off of that would qualify as comparables.
Okay.
But one of those has been sold since then, so why don't you have that one?
We can't use things, it has to be as of the date of the tax value, not as of today.
No, I'm saying it was the date of the tax value. That's what I'm saying.
Well, did you provide that information?
I am not the tax assessor, but I can do that if I need to do that also. I gave the two addresses, and 24 Gloucester Court has been sold since the value of this. You all have been overcharging me for a number of years now.
Well, we have information from the tax department. And if you want, these issues that you have to provide us with some evidence, like evidence of condition.
I said that the first time, and obviously you all didn't look into that because I sent that the first time, but I'm willing to do it again.
You provided us evidence.
Now, are you saying I need an attorney now? Is that what you're saying?
You probably need an appraiser is what you need to come out and measure the square footage and give you a value there.
And I'm supposed to pay for that even though your office has an appraiser. Is that what you're saying?
Either that or you can accept the appraiser's value that he came up with.
Okay,
We have our
who pays
appraiser
for the
value.
second appraiser if mine is correct?
If you have another appraiser, if you hire an appraiser who comes in and has a square footage, then that will be evidence that we can consider.
Okay, and even the original purchase deed with the square footage?
Well, it doesn't really matter. If the square footage isn't correct in the information you have, it needs to be corrected. We need to have the actual square footage. And it may have been an error.
I'm saying if that's what was sent, so you're saying that's my legal document and that's not good enough? I just want to be clear on what you're saying this time, because this is not what we were saying the last time. So I just need to know for my next step, what I need to do. Since the square footage is off, it is rental property, and Mr. Westry did admit that he didn't know that last time. And the condition is comparable to the ones you have appraised at much lower tax value on the same street.
Well, ma'am, there was a dispute about the square footage, so he went back out and measured again. There was a question about the condition. He went and checked the condition, and he feels that the condition is average, like he did the first time. He considered the comparables that you provided, which apparently were just other tax values. So the county has done, everything it should have done. Now, if you have other information that you can supply as far as square footage, we'll be glad to consider it. But if you don't have it, we can't really, just saying that it was on the deed. First of all, square footages aren't on the deeds. So I'm not sure what you're referring to.
Okay, my daughter is an attorney in real estate. She doesn't practice in Durham, but when I die, she will be the owner. I have no problem doing the legal way if that's what the county wants to do. But when we left and I always take notes on what's said in any kind of meeting, and I did not have condition even down there. And square footage, I know is not 2,600 square feet, okay? And now if you need evidence, I can provide that. But I am really annoyed at how much time my taxpayers' dollars are going to having people come back 2 and 3 times. I will do it, but the expense of an appraiser, now who's paying that, if I am correct?
Well, I'm sorry, ma'am. We have to have evidence, and however you get that
I
evidence.
can get the evidence. You're saying I have to pay to get the evidence. And if I am correct and yours was inaccurate, who is paying? I'm not here. That's why we're here, to reduce all this extra I've been paying. And I was very cooperative the first time. I'm trying to just get fair and equitable treatment. That's all I'm doing. And I know that part is not true. And now that you know that it's rental property and it's empty, and was empty at the time that you assessed this.
Okay, well, Mr. Wester considered all that information, and we're going to need to move on.
Yes, we are. Yes, we are. Did I get what you're saying in writing then? Thank you.
Okay, Mr. Beatty, you want to add something?
Yes. She does not have to employ an appraiser to get her square footage measured. She can do that herself. It's very simple to do. What are the measurements or the dimensions to the house? And she could check those measurements with our property record card to see that we have measured the building correctly. That way she could have some level of confidence or lack thereof as to the dimensions or size that we have with the dwelling. So it does not have to cost, because I think that her main issue here I'm hearing is the square footage, and that can easily be checked. And to keep from having her to pay an appraiser to do it, she can check the measurements, which if the measurements are matched, then the square footage would be correct.
Okay, you hear that, Miss Austin? You can measure the house
I heard
yourself.
that, but let me make it clear for the record that my main idea was not just the square footage. It was the comparables that you gave were not similar to what my home is, and then compared to the ones on the same street. Those houses are about the same age and condition and square footage.
Okay,
And they are considerably lower than mine. So I don't want it just to square footage, even though I'm prepared to prove that. And thank you to the gentleman who gave the suggestion that my measurements would be acceptable. I didn't realize that. Thank you.
Okay.
Mr.
All right.
Chair,
Let's move on with this.
thank you.
What's the pleasure of the board with this case? We've already continued it once.
No, okay, and can we speak? The county went back out and verified the square footage, correct?
Yes.
Okay, that's all we have to go on. And the comp that was submitted, he looked at those and they were not qualified comps. So I'm at the position of siding with the county in terms of the value.
Okay. Any other comments? Jeanette, you're muted.
Yeah, I'm in agreement with David. I mean, if the county went out there and measured it and verified that measurement and all things said, and does it being a rental property make a difference to the value? I don't see that it does.
No.
Yes, it does. Legally, it does make a difference.
In the tax for tax records. It does.
Yes, it does. Yes,
Okay.
it does.
Mr.
And that's
Beatty,
why when
wanna
I
add
left here the last time.
Mr. Beatty, did you want to add something?
Yes, sir. It seems that this, I know we don't want to continue things, but if Miss Austin was to meet Mr. Westerly on site, that could really solve some of what these problems are. But if she's not going to go to the site, that's another story. But I think the two of them together on site could solve some of these issues, if that would be possible.
Okay. Well, I thought that's what was going to happen last time.
Nobody said that to me. I certainly would have canceled class and come. I'm a teacher. We have gone back face to face.
Okay,
But
all right, well, so what do you all think of that recommendation? Would you like to continue it again?
I wouldn't.
Jeanette, Tony?
Well, I guess, I mean, based on what Travis has said, if he went back out there and measured, and it looks like a pretty simple house to measure, looking at the picture, it looks like a straight up 2-story with maybe a family room off to the side. If those measurements were verified, I feel comfortable with going ahead and upholding the county's decision.
Okay. Would you like to make that in the form of a motion?
I make a motion, we uphold the county's decision.
Do I have a second?
Second.
All those in favor say aye.
Aye.
All opposed? All right, Miss Austin, we're going to go with the county's value. You can appeal this to the state.
Okay,
Yeah.
that's the North Carolina tax appeal.
It's the letter you get from the tax office will tell you how to appeal this value.
Okay, would you record that on the record that I am going to appeal?
Okay. All right. Thank you, Miss Austin.
Thank you.
All right, let's move on to the next one. Do we have somebody, Bill Padford? I thought I saw you here a minute ago. Randy Padford.
Yeah, it's William Randall, so I go by Randy. Yes, thank you.
Okay, all right. Let's get you sworn in, please, if you'll raise your right hand. Swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And are you comfortable using this Zoom format?
I am. We've all gotten used to Zoom, I think.
Yeah, necessary evil these days. Okay, Mr. Westry, you saw I already swore him in, so that's why I'm not going to swear him in again. What do you have for us on this one, Mr. Westry?
Yes, this parcel here is 1019 Unbridled Street, parcel number 227933. And the homeowner provided me with an appraisal to basically to reduce the current tax value of $614,000 and $430. And he wanted to basically get his tax value down to what he purchased the home for in November of 2020, which was $578,500. I could not use the comps that he provided because the comps were not in the neighborhood. It was a completely different neighborhood, another new neighborhood, which was 751 South. And those homes are kind of not comparable to this neighborhood. So I did provide him with comps to justify this value, and he was still unsatisfied with the current value that we have.
So he provided you with an appraisal, you say?
Yes, and the appraisal used homes that were they did not use any homes that were in that neighborhood that had recently been sold. They used homes from 2020 that were sold in a completely different subdivision that was located about 1.5 miles away.
Okay. All right, Mr. Pafford,
So I guess my major argument is the simple one. EPCON, which has, I think, 5 communities in the Triangle area, values this house at $578 something. That price was determined partly when we signed the contract in September of 2019. We selected the floor plan, screening porch, and so forth. And then there was a design phase in the spring of 2020, and we picked carpet and stuff like that. So the final price was determined by EPCON, which is an experienced builder in the area, at $578 and $490 or so. And I just don't understand why. And the bank appraisal came in about the same. And I'm just not understanding why that's not a valid value.
Okay. Mr. Wester, you have any, it sounds like you've covered it pretty well. Do you disagree with the comparables that the appraiser used?
Yes, we couldn't use their comps, but everything we have listed on the property record card for this property is accurate, even compared to the appraisal. The sketch and the square footage of the home is accurate. I did notice a couple of differences in the appraisal. The appraisal had actually appraised the land at a higher value than the county did, but he appraised the house. He appraised the house at a lower value.
Okay. All right. Any questions from the board or comments?
Can we see the comps, David? That you use?
Yes, excuse me. I
With the
sent
county.
5 comps in as part of my evidence, and
Okay,
they're
for the
all within
county.
a half a mile of the neighborhood.
Right. Jim, can you show them to us?
The comps that the county used.
Yeah, we want to
Yeah,
see both.
give me 1 second. I'm working on trying to get these files open. They're
Okay.
running pretty slow. Yeah, give me a second. I'm going to probably restart the appeals module.
While we're waiting, can I ask Travis if the comps he used were in the same neighborhood and the same time frame as this house was sold?
Yes, this is of course, our schedule of values are based on the 2019 reval. These homes were built in 2020. So from the period that these homes were sold, there were homes sold for that 570,000 up. Comparable homes that were sold anywhere between 578,000, similar to the subjects. But there were also homes that were sold for $640,000 that were comparable to the subject. And I felt like we were right in line at $614,000.
Okay, and they were in the same neighborhood.
In the same neighborhood.
Okay.
But can I ask a question about that?
Yes.
So, but I thought the valuations were based upon what the house would have sold for in 2019 had it existed. Is that correct?
Correct. So that's when I said that the schedule of values were based on 2019. That is what the values were based off of. Until the schedule of values are updated, everything is still based off of the 2019 reeval.
Right. So Epcon has built numerous houses in this area, and they think, and I've worked with Epcon, if they thought they could charge more, they would. They thought the house was worth $578 in 2019 and 2020. So I'm just I'm not understanding why that's not very compelling evidence. It's not a one-off sale. This is EPCON's pricing for these houses.
And you had it under contract as of when?
So we signed the original contract in September of 2019. And the pricing was partially established based on the floor plan, the screened-in porch and such. The final pricing was determined, I believe the document I have says was June 2020, after we'd picked carpet and appliances and all that kind of cabinets and stuff. So that 578 is what EPCON thinks it costs to build that and what they could sell that house for as of, late fall, early spring, that time frame. And since housing prices were going up all through this era, I mean, if EPCON of the house was worth 578 at the end of 2019, I would think that the January 1, 2019 valuation would actually be less, not more.
I mean, what did the appraiser come up with?
I mean, the bank gave it the usual. Banks always assess it about what,
Contract price.
Yeah. But I mean, the appraisal just shows, again, we're supposed to be looking at the 2019 valuation. So, I mean, yes, you could sell it for more than 578 today, but that's not the 2019 value. Okay. And all the comps are within a half a mile, and they're the same general area, very close to South Point. I mean, it's not the same neighborhood, but you walk through it, it's not radically, it's smaller lots, similar sized houses. I mean,
well, this is showing 1.3 miles away, but
not the ones I sent.
Oh, I'm looking at the appraisal. Can you scroll down so we can see the date of this valuation, Tim? Okay.
It would have been late 2020.
Well, it says September 4th. Okay, can we see his comparables now, Tim?
85.
Did you mean Travis's comparables or?
No, the one that Mr. Pafford sent.
And then those were obviously 2017, 2018 sales because they're supposed to match the January 1, 2019 values.
Right. And are these in your same neighborhood?
No, as Travis says, it's a different neighborhood. This is a new neighborhood, and they broke ground like in June of last year. But if you look at the map up there, see, that's the new neighborhood. And you see 4 of the comps there are they're less than a half a mile away. So you get the same amenities like doing South Point and stuff like that. And the comps, I tried to pick ones that were the same size or larger with similar size or larger lots.
Okay. All right. Any questions or comments from the board?
Well, these comps were all built in 05 and 04, so they're a lot older homes.
Mm-hmm.
Those comps are.
Yeah, I agree.
And you're talking new construction.
Yep.
I think the appraiser, from the appraisal, those comps are actually better than the ones that Mr. Pafford provided for whatever that's worth.
Yeah.
And he appraised it for 585.
If you go at 585 and David, didn't they have a 5% variance on that? If you did, you still be from the counties. I like being in the same neighborhood though. Comps. And then I think if you take the 585, the difference from that falls within the margin anyway. So I'll go on record. I'm in support of the county's position.
I can support that.
So if you take the 5%, and you're talking about.
Well, it is outside the 5% range.
Yeah, I'm just saying, I'm saying if you use the 585, probably about $2,000 or $3,000 roughly, $4,000 or $5,000. I'm just saying, I mean, that's just one factor. The other factors for me is, the comps in the neighborhood in terms of where they come from.
All right, well, you prepared to make a motion?
I'll move that we accept the county position.
Do I have a second?
Second.
Any other discussion? All those in favor say aye. Raise your hand.
Aye.
Aye. All opposed? Okay, it passes 3-1. Sir, you can appeal this to the state board.
And I probably will, because I'm still just not understanding why EPCON's valuation in late 2019, given that tax value is supposed to be based upon a January 1, 2019 value, is not a very strong. I mean, this is $500 a year to me. I just don't understand the rationale not using the sales price.
No, I agree with you. It is a little unusual, but when you're talking about a different neighborhood, we feel that the neighborhood is very important. So anyway, thank you, sir.
Okay, thank you.
All right, let's move on to the next one. Miss Auld, is that how you pronounce your name? Auld? What? Wait, you're muted, ma'am. You're muted. There, can you? I think you've. Miss Auld? Ms. Auld, can you hear me?
She just sent the message and said, yes, she can hear everyone.
We can't hear her.
She says she cannot see. She's not sure how to get off mute.
Can you turn your volume up? Maybe it's just your volume, because it looks like your mute is off. Or your speaker, your microphone.
The mute button, if you're looking at it like I'm looking at it, your mute should be to the far left bottom of your screen. If it has an X on it, that means you're still on mute.
Something must be up from her message that she just sent us, and said that it has an exclamation point on the microphone, and I do not know what that means.
Hello, this is James. I think that means that it's saying she doesn't have microphone input to her computer.
Audio, yeah, that might be the issue.
Yeah. She might have it turned on. Miss Auld, we're going to have to skip ahead and keep trying, and we'll come back to you. And you might have to use a different computer or something else to contact us or be able to be heard. All right. Okay. All right. Let's move along. Let's see. The next one we've got is Crown CHH LLC. Is somebody here from that property? All right, well, let's get going with Mr. Streeter. Are you're here, right? Get you sworn in, please. You raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name and position, please.
Jack Streeter, commercial appraiser with Durham County.
Okay, and what do you have for us on this on Crown CHH?
You want to go ahead with Crown? They did have 2 other appeals, so they might have these times mixed up. But so we had it's actually one commercial lot that is now 15. It's now 15 acres. It's under appeal for $5,582,481. The appellant's assessment, the appellant's value is $2,645,836. Excuse me. The subject was actually purchased, and we're talking about the Crown Honda at 951 South Point Auto Park Boulevard. It's 15.433 acres, parcel number 143,592. The subject parcel, it was actually purchased January 9th, 2018. At that time, it was 2 separate parcels, but they actually had 2 separate sales on those parcels. Parcel 143,592 was 9.428 acres. It sold for $5,973,500. Parcel 143,594 was 6.021 acres and sold for $3,027,000. The parcel again was combined, and now there's a new Crown Honda currently being built on the property, and we have the permit number on file. The subject.
What did it sell for per acre back when it originally sold?
Okay. The original sales were for the 9.428 acres. It's on the screen here. It sold for $633,591 per acre, and the 6.02 acre tract sold for $740,000.
Okay, and that was basically a year before the tax valuation.
Yes, sir.
And so, what are you valuing the properties for now?
We have both combined at $5,582,481, and that's 361,466 per acre.
So that's significantly less than they paid for it.
Yes, sir.
And these are the comparables here that you used?
Yes, those are the comparables that I used. It was difficult finding comps that were close to the subject property that were comparable in size. That's 751 South Point area. We did find one that was close. The closest comp that was 4.496 acres. That was the largest one that was close, and it sold for $333,629. But I added this sales sheet later because I wanted to show, even though these are a lot lower, that's why they're separated down at the bottom. We have some that's very close to the subject on NC 54 and 751 highway. These are 0.983 acres for $339,776. And the other one sold, it was 0.973 acres, and it sold for $1,119,218. So those, I wanted to add those in to show that the values out there at 751 highway are a little bit higher than what's normally going on in the rest of Durham. We also have Hobson Road, and that's Hobson Road and TW Alexander added in. That's going towards RTP, and I feel that those were actually comparable area to the subject property.
Okay, did they provide any information about what they thought the value was?
Yes, they have sales. They have 5 sales that they actually provided. The parcel numbers, I had to chase down some of these because the parcel numbers are incorrect, but we have comp 1, 2, 4, and 5 are all disqualified in our system because these are multi-property sales, which they're more than one property sold at the same time on the same deed. So we disqualified those properties. Then we disqualified those sales. So I didn't use those sales. I disqualified those sales. We actually offered, I actually just showed you those 9 sales, but I do have some notes about their sales. 1 second. Okay. So sale 1, it was a 10/9/2018 sale. We actually found that as parcel number 151279. So for $5,800,000. That was parcel 154067, 154070, and they were combined before the sale. They irregular shaped lots in a floodplain. Cell 2, that parcel was parcels 141, 161, 141, 151, and 204614, and now they're combined to 141, 161, and they're actually now residential townhomes. And cell 3 was extremely irregular shaped lot in a floodplain with parking area and driveway for another building on that parcel. Cell 4 is parcel 1538559, 153768, 153858, and they're regular shaped lots with a cell site in the middle of the separate on a separate parcel in the middle of this parcel in the middle of this tract, and it is in a floodplain, and there's railroad tracks close to the subject property. I mean, close to the comparable property. Cell 5 is parcel 215 085, 152 975, 152 978, and 152 979. They were purchased and sale, and they were both combined to 152 975, and currently is an apartment complex. So
what's the zoning on the properties that we're talking about, though?
The zoning on the subject property?
Subject property. What's the zoning on those?
Let me make sure I'm right. But it's commercial. It should be in my on my comp sheet. Can you bring that comp sheet back up? Sorry, I lost you guys. It does not. Give me 1 second.
Okay.
Okay, I'm having trouble with my AS100. Tim, do you have an AS100 session up? I'm not sure why mine's.
I do. 1 second. Get there.
I see what's going
I guess
I see.
it'll show it.
Yeah, I see the problem now. Okay. Commercial general.
Yeah, I was noticing that the comparables that they used, all but one of them was either office or residential or
Yes, sir.
industrial. And, you know, those values are going to be lower than a general commercial value. They only had one that was commercial, and that one is 25 acres. And you say there was floodplain on that one, or what was the story with that one?
25 acres that was sale for.
Oh, sale one.
Oh, sale one. Sorry.
That's the only one that has the same commercial zoning.
Yep, irregularly shaped lot in floodplain. Now the subject does have easement, and we actually have it adjusted downward. Okay, we have it adjusted downward for topo, and we have residual, I think 6 acres. Yep, 6.77 acres, 773 acres in residual, and that accounts for the retention pond and the easement that's on the property.
I'm looking at their adjusted value is not that far off from your adjusted value.
Yeah.
276, and you're at what, 3? What was your value? 361. So
361 is our per acre value. Yes.
Right. That's right. That's what I was looking at. So, you know, is anybody have they come in? Anybody for this property come in?
Well, see, this was continued. And someone showed up last time. That was the issue was he was not an attorney working for that company. He was a tax rep. So right. I'm not sure why no one's here today. I believe they talked to them. I believe they were talking to them before, but I'm not sure why they're not here.
Okay. Well, I'm just inclined, since these comparables are office and industrial and residential or 25 acres, to think that your comparables are better. So I don't know if there's any other questions or discussions from the rest of the board. David?
I'm in agreement.
Yeah. Okay. Then I will entertain a motion on this is number 37.
I make a motion we uphold the board's evaluation of this property.
Do I have a second?
Second.
All those in favor say aye.
Aye.
All opposed? Okay. All right. Let's move on to the next one. The Durham Marriott Hotel. Do we have anybody here from the Marriott?
This is Reed Hollander. Can you hear me?
Yes.
All right. This is the Imperial Hotel Group matter, parcel 157963. Is that correct?
Yes.
Yes, I'm here on that matter.
I thought you said the Marriott, Dave.
No, you're on with the Imperial Hotel Group. Is that correct?
Yeah, that's number 39.
Okay, so that's 39.
Okay, I just wanted to double check.
Okay. All right. Is anybody here for number 38, the Durham Marriott Hotel?
Same, right? I believe.
Same. Okay. Well, let's go ahead.
Well, hold on one second. Is the Durham Marriott Hotel property that you're talking about let me check that parcel number, 103047?
Yes.
Yes.
Okay, then yes, I'm also here on that one.
You're here for both of them?
Yes.
Okay. All right. Well, let me get you sworn in, please, if you'll raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Are you comfortable using the Zoom format?
I am.
And what's your relationship with these two hotels?
I'm an attorney. I represent both of these taxpayers.
Okay. All right. Well, we'll come back to you. Let's hear from Mr. Streeter first. Okay. What do you got for us on? Just pick whichever one you want to go with first.
Right. It's pretty much the same argument for both properties, but we'll start off with the Durham Marriott. So under appeal is the Durham Marriott Hotel, 201 Foster Street, parcel number 103047. The value under appeal is $16,464,514. The owner's opinion of value is $11,525,160. This property was appealed in 2019, and the value was upheld by the board. The current appeal is based on the impact from the public and private sectors for the reaction to the pandemic, resulting in a decreased revenue. The appellant states that the statute 105-287A-2C allows for a reduction in value because they view the emergency orders as a change in legally permitted use of the property. Also, General Statute 105-287A-3 that the decreased revenue was not a result of the three changes that are not allowed. We actually have the statutes in the case file, but 105-287-2C recognizing an increase or decrease in value of property resulting from a change in legally permitted use. The county contends that the mandates did not change the permitted use of the property as of January 2021. Statute 105-287-3B2 is recognizing an increase or decrease in value of property resulting from a factor other than one listed in subsection B. In a year in which general reappraisal of real property in the county is not made, the assessor may not increase or decrease the appraised value of real property as determined under GS 105-286 to recognize a change in value caused by the statute that they're addressing is 2, inflation, deflation, or other economic changes affecting the county in general. The county contends that the effects of the pandemic, including both public and government reaction on the subject property, are economic changes that affected the entire county. GS 105-287A-3B2 applies. Also, that the closures or capacity limitations are not a change of use for the property, and that GS 105-287A-2C does not apply to the subject property. The property was still able to be operated as previous use as of January 1, 2021. So our recommendation is to uphold the assessor value of $16,464,514.
Okay, Mr. Hollander, what's your testimony for this?
Thank you, Mr. Smith. And members of the board of ENR, my name is Reed Hollander. I'm an attorney with the Nelson Mullins firm in Wake County, and I represent Shaner Hotel Group, the owner of the hotel at issue in this matter. Before I get into my argument, I want to just double check. The current valuation, as I understand it, is $15,464,514. Is that the number that you have, Mr. Streeter?
Sir, let me double check.
I thought I heard you say 16,464,000, and I just want to make sure.
Yes, 16,464,000. I noticed that on your sheet, and I thought it might have been a mistake, but I'm in the system now and see. I'll check I'll double check the website just to make sure that's not maybe a different bill, or
that might be a typo on my end. So I apologize.
No problem. I'll double check. I know I believe the property is a leasehold also. So maybe it's a difference in the land value versus the I mean, the land bill versus the improvement, but I'm double checking right now.
Okay.
So yes, fair market value on the website, 16,464, 514, and
Okay.
to the
So
bills.
that's a typo on my memo, so we can correct that. So members of the board, I submitted a memorandum in support of our appeal. I just want to confirm that you all have that available to you. We have not seen it yet, but I'm assuming that we can access it now. Yeah, that was submitted some time ago, so I don't know how the process works on your end, but that was submitted back on August 3rd to the county tax office. But I'll
Jack,
talk.
you saw that, correct? The memo?
Yes, it should be on file.
I'm going to talk through the substance of the memo, so I just wanted to make sure you all had that and knew that we had filed that. So as you all are very well aware, properties are appraised on a cycle, and in the year of the revaluation, the values are determined and they remain the same for the remainder of that cycle unless there's some change that the law recognizes as a basis to adjust the value. And the statute that sets forth the types of changes that not only allow a change of value, but in fact require the county to change value is General Statute 105-287, which Mr. Streeter has put on the screen in front of us. And that is the statute on which we based this appeal for tax year 2021. This is a hotel property. And as I think we're all very well aware, and our memo sets forth in some detail, hotels were dramatically affected by the COVID pandemic. The ability to operate the hotel was dramatically limited by a series of governmental orders, both state orders and county orders. And our memorandum cites numerous executive orders issued by Governor Cooper. Those are in footnotes 2, 3, 4 of our memo, as well as multiple declarations of state of emergency issued by the city of Durham and by Durham County during 2020. And that series of executive orders by the governor and emergency orders by the city and county of Durham dramatically limited and restricted the legally allowed uses of this property. It became illegal to do certain things with this hotel property. For example, to hold gatherings, to serve food except under certain conditions. Yeah, that is my initial appeal letter. Separate from that, there's a memo that provides more detail. So among the limitations were mandated closures of or capacity limitations on the bars and food service offerings at the hotels, mandated closure of fitness facilities, drastic limitations on the number of people who could gather in rooms. Some of the restrictions, in fact, imposed by the county and city, in fact, exceeded the restrictions imposed at the state level by the governor's executive orders. And at times, discretionary travel was either strongly discouraged or banned. You will recall that there were various curfews and essential travel only rules put in place with civil and in some cases criminal sanctions for violation. So it is our position that the legally permitted use of these hotels was altered by government action. I think it is difficult to argue that there were not legal restrictions placed on these hotels that limited their uses. They're not permanent restrictions. We're not contending that there was some permanent change, but that statute doesn't use the word permanent. It doesn't require that the change in legally permitted use be permanent. The fact is, during 2020 and as of January 1, 2021, there were severe and significant legal restrictions on the use of the property. In addition, and Mr. Streeter, if you'll put the statute back up on the screen, that just make it easier for all of us to look at the language of it. So that would fall under 105-287 subsection A to C. Subsection A3 is a different provision that permits, in fact, requires the county to increase or decrease the appraised value of real property resulting from a factor other than one listed in subsection B. That's what Mr. Streeter was also saying. Subsection B sets forth the 3 reasons why a change would not be made. And the one that Mr. Streeter focused on was B2, which says inflation, deflation, or other economic changes affecting the county in general. This is not, and obviously that is designed to recognize that, certainly in years after a revaluation, there are changes in the market. I mean, markets change, values go up and down. Those aren't the basis to alter values after the initial assessment in the year of the revaluation. This was not an economic change affecting the county in general. This was a pandemic. The pandemic affected the county in general, but it had disproportionate effects on hotels as distinct from other types of properties. For example, you would not see the dramatic decline in market value if you look at residential properties in Durham. They did not suffer from the pandemic in the way that hotels did. In fact, I can't think of a type of property more dramatically affected from a market value perspective than the hospitality industry. And so it is not an economic change that just generically affected the county. It is a pandemic that, while certainly affecting the county and the state and the country, had disproportionate effect specifically on this industry. So we believe that subsection 3, an increase from a factor other than one listed in subsection B, is also met. And let me be clear, the statute doesn't require that we meet both of those triggers. Either one of them independently is requires a reappraisal by the assessor. If you look at subsection A, 105-287A, the assessor shall increase or decrease the appraised value of real property to recognize a change in the property's value resulting from one or more of the following reasons. And then you have that list. So if one of those reasons exists, the assessor shall reappraise the property. We have provided, it is my understanding, and this is consistent with every other county I'm aware of, that Durham County appraises hotel properties using occupancy figures and revenue per available room, which is abbreviated as RevPAR in the industry. And because that's how hotels are bought and sold. When somebody goes to buy a hotel, they're looking at what's the income stream I'm going to get from my purchase of this asset. And that's driven by how much revenue is coming from those rooms and what occupancy they're generating. The subject properties occupancy declined from 76.9% in 2019 to 26.5% in 2020. The revenue per available room dropped from $118.36 in 2019 to $35.03 in 2020. So these are massive decreases in both occupancy and revenue. And they are directly associated with changes in the legally permitted use of the property. Now, I would not contend that's the only basis for the drop. Obviously, people made independent choices to travel or to stay in hotels or whatnot. But the fact of the matter is that there is an initial, in my view, there is an initial legal question. Is the trigger of 105-287 met? Has that occurred? And if there's a change in the legally permitted use of the property, which the state and local orders plainly restrict that use, that trigger is met. Once that trigger is met, the question is, what's the decrease in value of the property? And so it is our contention, we did not just take a straight line approach and say that, because occupancy dropped from 76 to 26% and revenue from $118 to $35, that there's a similar 60 or 70% decline in value. The reduction that we've requested is to 11,525,160. And I'll tell you that the way I computed that, and because I might have had an incorrect starting number, I may have made a math error, but that's a reduction of 30% in the value. That's how we came up with that number. And I will tell you that the basis of that 30% is my discussions with hotel appraisers who focus specifically on the hotel industry, who indicated that the general view that they had seen, and first of all, hotels weren't transacting. Nobody wanted to buy a hotel in the middle of the pandemic for obvious reasons. So there are very few sales to go by. But for the sales that did transact, the reductions in value across the board were in the 20 to 40% range between 2019 and 2020. So I took the midpoint of that range and took 30% as the requested reduction. And to perhaps simplify things a little bit, the argument is the same for the Imperial Hotel Group, the next property. It's the same issue. So, we can take them one at a time, whatever the chair pleases, but I just wanted to let you all know that the same issue is coming up in the next case.
Okay, so what I'm hearing from you is you're saying that the use has changed, and it's not really the main use of it is a hotel, and that was not really changed, it's just reduced. But you're talking about the accessory uses that were really no longer legally permitted. The restaurant, the convention center, those sort of things were no longer legally permitted.
There were a number of changes imposed. They affected the pool and the fitness area. They affected the food service and beverage service at the hotels. They affected the convention space, and of course, both this hotel and the Sheraton Imperial have significant convention space. And they, to some extent, affected rooms as well. I mean, you had closures of rooms for cleaning. In some instances, hotels either just closed every other floor to create distancing, separation, or they would close every other room to create separation. So the effects of the steps taken to mitigate and to comply with government orders ran the gamut through a variety of aspects of the hotel.
Okay. Well, I guess my thought is it's not just these two hotels that were affected. It was all hotels. It was all restaurants, all entertainment facilities. I mean, if we were to reduce the taxes on this, I think we'd be reducing probably a fourth of the tax base in the whole county, following your logic, because a lot of those are the high dollar properties. And that concerns me on the one hand. And I understand what you're saying about the lease, but the primary legally permissible use of this property didn't change. It was reduced, and all the accessory uses were no longer, you couldn't do those anymore. And again, it's a temporary thing. But I just think that the impact, if we were to do this for every single property, would be really, really a major concern to the county and the state.
May I speak to that, Mr. Chairman?
Yes, you may.
I would say a couple of things. First of all, the appeal deadline has come and gone. So anybody who was going to appeal has had their opportunity to file their appeal. And if they elected not to appeal, or they failed to raise the argument that they should have and could have raised, that's, that they're, that's the consequence that they've chosen. So there's nothing that, in my view, requires this board to change the value for any other property that did not appeal. So I think this is a limited issue to these properties that did appeal on this basis. And as far as whether it, whether this argument does pertain to other types of property, it's interesting. I do a lot of property tax work. I gave this a lot of thought. I generally think that hotels and possibly restaurants and bars to some extent are about the only properties that really have this argument. Your commercial office buildings, they might have chosen to not, to work from home or whatnot, but the value wasn't impacted. If you look at the prices at which commercial office buildings were transacting, you don't see these declines in value, right? The people can still do their work for the businesses that own this office space, even though they're not there. But you can't remotely live in a hotel. You're either at the hotel or you're not, right? You can't remotely have a convention at the hotel. The hotel's not going to get the revenue from the people that are there eating or drinking or occupying the convention space if they're not physically present. And so it's a very different situation for them than it is for, even take restaurants. They can serve food to go, and obviously the vast majority of them transition to that to make do and still provide food service. But you can't remotely give somebody a bedroom to stay in. You have to be there at the hotel. So I think it is a distinct situation that's unique to hotels that doesn't impact other industries in the same manner.
Well, we have to be consistent. So, if we were to do this with your hotel, we would need to go do it for all the hotels. In the same way we would, I don't know about restaurants. I guess somebody would have to bring up a specific restaurant. But that's part of what we do. We're equalizing. So we would have to go redo all the hotels. And again, this was a temporary thing. And yes, some of the legally permissible uses were no longer allowed, but the main legally permissible use was allowed at a reduced level, but it was still allowed. So I tend to think that the county's correct with upholding their value. And I'd like to get some input from the other board members.
I've got a couple questions. Are they asking for just a reduction in the value for the year 2020? Then it would go back up to the other established value.
So this is an appeal for 2021. So the request is for a reduction in value for tax year 2021. Okay. If the legal restrictions no longer existed on January 1 of 2022, then that would be yet another change in the legally permitted use. If the restrictions all came off, then the value would go back up, because you would be back in the position you sort of started in, and the value could, it likely would go back to the value it was set at the beginning, assuming all those restrictions were no longer there.
And then my other question is, as our county attorney reviewed this statute, and it mentions 105-286 in amongst all of this, has our county attorney reviewed this and had an opinion on this? I mean, we're really getting, I feel like I'm asking to play attorney for the county in this one. Hi,
Hi, board and David. This is James. I'm the commercial appraiser supervisor. If you could swear me in, I will speak to that matter and add a few thoughts.
Okay, can you turn your video on?
Yes, sir. Let me get that.
Okay, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name and position with the county, please.
My name's James Roberts, and I'm the commercial appraiser supervisor.
Okay.
So to answer the question, yes, the county attorney has reviewed this appeal, and Jack has basically given you the stance that, or the interpretation that he provided to us, in that we believe 105-287 3 or I'm sorry, 105-286-2 is applicable in the economic changes affecting the county in general, and that the legally permitted use of the property has not changed in its use as a hotel. So those were findings from the county attorney. Some other thoughts I just wanted to add were, if we were to look at this property, obviously we're looking January 1st, 2021. So any consideration of executive orders or county orders would have to be based on what was in effect at that time. And Mr. Hollander mentioned the fact that he's not solely looking at a 60% reduction because of that. So that's part of the things that are at play. Obviously, the economic impact is intertwined reasons that are, in my opinion, impossible to separate from what would the public choose to do versus what government orders may have said can happen and cannot happen. Also, when we look at an income approach, we're always trying to find 3 years history when we do an income approach. And that is specifically because we're trying to project into the future. What are the anticipated future earnings so that we can establish what somebody would pay for those anticipated future earnings. While there's temporary orders that may have adjusted the way things can work, they didn't prevent changes in the way things work. There's a hotel that in Durham that actually is put up tents, right? So they did meals in the tents, and then they tied the tents to rooms. So they had to think outside of the box, but they found new ways to generate revenue. And there's no law that said you couldn't think outside of the box and generate more revenue. That falls on the ownership to be able to do that. And let's see. The other thing I just wanted to point out is that there was a sale of a new AC hotel that occurred this July, and it occurred in excess of $200,000 a room. We don't have either of these hotels at that rate. We have them both below $200,000 a room. So I would suggest that sale is evidence that the market's opinion of the value of these properties is definitely different than it was mid 2020 when everything was bleak and looked, like there was no light at the end of the tunnel.
Okay. Mr. Hollander, do you want to respond to anything we just heard?
I think I've stated my argument thoroughly. With regard to the Durham County Attorney's position, obviously they're not here to make the legal argument. But I understand that Mr. Streeter has summarized it for you. I'll be very straightforward with the board. I mean, there is no case law on this. I mean, this issue has never come up before because, thankfully, You know, we all weren't alive back in, you know, World War I for the Spanish flu, and have not had to live with this type of pandemic before. So this issue has not come up before. I think it is a novel issue of law. You know, you know, whether this issue ends up being decided at the State Property Tax Commission or up in the appellate courts, you know, remains to be seen. I do think that resolving this matter with respect to these two appellants who did appeal on this basis, you know, rather than making statewide law on this issue, you know, you all can decide how you weigh that. But you know, what I heard Mr. Roberts say is that there were indisputably changes in the uses of the property, but that you know, the sort of overall use didn't change. But you know, that's the same thing as saying that, you know, you add an addition to your house. You know, the assessor gets to add value when you add an addition to your house, but you haven't changed the fact that you have a house. You know, you've made this incremental addition that's adjusted the value. Here, it is plain that the government bodies who had the authority to do so impose legal restrictions. They didn't outlaw owning hotels. They didn't shut the hotels down, but they drastically limited their uses. You know, and just like, you know, if you were to, you know, demolish a house or to remove a bedroom or what have you, you're changing the uses in a manner that adjusts the value. And I think that's what 105-287 speaks to. So I think the law not only gives this board the latitude, but in fact requires the assessor to make the change that results from the change in the legally permitted use of the property. So that's what I'd say in response to Mr. Roberts' points.
Okay. David or Tony, you want to jump in here?
I kind of agree with you about sort of setting a precedence at the county level. Also because I'm not completely aware of how the disaster relief would tie into that, and would that be double dipping? So it feels like this may be something for a larger body to decide.
Man, I think Mr. Holland presented a great argument. I'm sort of, I know it might open the door to whatever, but I think he's correct in his position. How you come up with 30% adjustment and might be looked at, but I totally agree with what he said. I don't know if we're in a position to, you know, do anything, but all of that, what he said to me made sense to me. Made sense to me. And different you know, different companies are affected different ways. And I do think that you can't compare the hotel, how it was affected to some of these other restaurants, like you said. So, but that's just, you know, that's just my opinion on that. I totally agree with 90% of what he said.
I think I would be more persuaded if it wasn't a temporary change in use. You know, it's not like they're outlawing this forever. You know, it should come back at some point where it's no longer an impact.
Mr. Smith, may I briefly address Ms. Kemball's point and your follow-up point?
Yes.
Ms. Kemball, with regard to the relief that was available, it's my understanding that the relief was largely directed at maintaining employment numbers to ensure that employers had money to keep their employees on staff. So to the extent that hotels or any other business took advantage of that, that effectively flowed through to their salaries employees. It didn't end up, it did not end up, it would have offset the expense they would have incurred to pay those employees salaries rather than, furloughing them or something of that sort. But I don't think it directly impacted the valuation of the hotels as real property. It might have impacted the business value, perhaps, of the overall business that they're operating. But from a real property value perspective, I'm not aware that that any of the hotels received relief relating to the value of their property. So I just wanted to comment on that. And Mr. Smith, my only comment with regard to temporary versus permanent goes back to one of the earlier questions, which is, we're here talking about a specific tax year, January 1 of 2021 appeal. This is not a permanent valuation change request. And if the value goes back up effective January 1 of 2022 because there are no longer any legal restrictions on hotels, then so be it. I mean, that the facts are what they are at that point. But I think I would respectfully ask the board to consider making the adjustment for the 2021 tax year, and then we and the county tax office can obviously discuss where things stand once we know what January 1, 2022 brings.
Okay, all right. Well, let's wrap things up. I will entertain a motion. I guess we need to do these separately, even though I think it's sort of the same argument. For number 38, that's the downtown Marriott.
I make a motion that we adhere to the county's evaluation, and I just feel that this should be something that a state appeal should make a judgment on rather than the local board.
I can.
A second.
I think it's going to be appealed one way. It'll be
above our pay scale.
Yeah, I think it's above. I agree with what you said, David, a lot, and I understand, but like I said, I would adhere and recommend that they do appeal to the state.
Okay, we're passing on up higher.
Yeah.
Okay.
I'm sure it will be one way or the other. It will be appealed. Okay, yeah. All those in favor, raise your hand. All those opposed? Okay, it passes 4-0. Yes, I assume you're going to appeal this, Mr. Hollander. And if you do, I'd be curious to know what the result is.
Yeah.
I expect that's what my client will ask me to do. And, we'll either work it out with the county like we do with many cases, or we'll have a precedent setting hearing and we'll see what happens. I really appreciate all your time. And I want to make sure you all vote on the second hotel as well.
Yeah, right. I was getting ready.
But I do appreciate your time and your consideration.
Now, it's an interesting legal question. Okay, yes, I will entertain a motion on item number 39.
I move that we uphold the county's recommendation.
Do I have a second?
Second.
All those in favor, raise your hand. All opposed? Okay. All right. Thank you very much, Mr. Hollander, and good luck in your process.
Thank you, Mr. Smith. Good to see you again. And thank you to the board and the county tax office personnel. You all take care.
Thank you. Yeah, thank you.
All right. That's all I have on the agenda. Mr. Beatty, have you got something for us?
Yes,
are we going to try to go back
to
number 36?
Right. Yeah, we need to go back.
36.
Now, one thing I was thinking, maybe I see her now with a microphone.
Can you hear me?
Okay.
Oh, she's there. All right.
Yes.
I've got to leave the meeting. I've got an appointment.
Okay. All right.
This is going to be very quick.
Okay.
Thank you for.
And is it pronounced Ald? Is that how you say your name?
Yes, sir. Like Auld Lang Syne.
Okay. I need to get you sworn in. If you will raise your right hand, please.
Okay.
You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And are you comfortable using this Zoom format now that you have a microphone?
When I don't have a browser working against me, I had to switch computers.
All right. Well,
Pretty sad, yes.
All right. We'll hear from Mr. Wester, and then we'll come back to you.
Perfect.
And as you've seen, he's already been sworn. Okay. What do you have for us on this one?
Hey there. This parcel is 1011 Unbridled Street, parcel 227931. This is pretty much almost exactly same as the previous appeal that we just did at parcel 227933. It pretty much the same exact comps was utilized. The homeowner did not provide any of their own comps or an appeal like the previous homeowner did. But the only major difference in this property was that the square footage was slightly a little bit bigger, and the sales price was $601,500. It was sold in October 30th of 2020, and the tax value is currently at $626,437.
And these are the comparables that you use, correct?
Correct.
Okay, Ms. Auld, what do you have to share with us?
Well, first of all, I want to thank Mr. Westry for his help, because a lot of the information that EPCOM provided on a number of the houses in the neighborhood were incorrect. So we did have to go back and forth a little bit to make sure the square footage was accurate and a few other things. But he's also right. Mr. Pafford and I are not next door neighbors, but close by. And we have a very similar floor plan. There are a few changes between the two, but not really relevant probably to the discussion. I think the main thing for me is Mr. Pafford and I agree that the best way forward to deal with this is what the sales price of the homes were, because those prices were decided in the fall of 2019. So rather than to bore you all to death, because you've heard the arguments before, I really don't have anything new to add. So it would be nice if you would at least entertain the idea of using that as the tax basis as opposed to the value that was put forth at over $26,000 more than I paid for the home.
All right. Any questions from the board? Any discussion? It is very similar to the last one.
Yeah, it is.
Okay. And I will entertain a motion regarding this one, number 36.
I move we uphold the county decision.
Do I have a second?
Second.
All those in favor, raise your hand. Which way are you voting on this one, Tony?
I said second. I'm sorry. I meant aye.
Okay, you're in
I'm
favor.
behind.
All right. All those opposed? Okay, then we are going to uphold the county, and you can appeal this if you'd like to the state board, and the information about that will come from the county letter. Okay.
Okay, thank you. And I probably will look into doing that. But I do appreciate your time and your patience with my technological problems.
Okay,
so thank you very much. Have a good rest of your day.
All right, glad you got it straightened out. Okay, all right. Anything else? Courtney, you got anything for us?
No, I don't have anything, but I'll keep you all updated on the next meeting.
Starling, you okay too? Nothing new?
No, we have nothing new. Courtney, when's our next projected meeting?
We don't really. Yeah, I mean, the appeals that are waiting a hearing or have been asked to be continued. One person wants to do in person, and we have no idea when that will happen. And the other wants some cases with the PTC to be closed first. So don't really have much to work with right now.
And you have my dates when I'm out of town, correct?
Yes.
The 16th and the 23rd, I'll be gone. So.
Okay.
Okay.
All right. That's it.
Okay. Thank you, everybody.
Guys.
Okay.
All right. Thank you all.
Great seeing all of you guys.
All right.
All right. Have a great week.
Good seeing you
Everybody
too.
be good.
Have a good one.